Good morning and welcome to the Shenkman Private Client Group Accountant Attorney Summer Webinar Series. This program is entitled U.S. Immigration in the Time of Corona. For those who don't know me, my name is Jonathan Shenkman. I'm a financial advisor, portfolio manager, and an accredited investment fiduciary at Oppenheimer, based in New York City. The goal of all my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. I also handle their life, long-term care, and disability insurance needs where applicable. In addition to the 20 to 25 events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You could read my work in Barron's, CNBC, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. After the program, I'll send out a link to all the publications where I publish my work. Today, we're privileged to hear from Steve Maggi, who's managing partner in SMA law firm. Steve specializes in U.S. immigration and consular law. The firm prepares petitions at U.S. consulates in South America and around the world, including investor visas, tourist and business visas, while simultaneously handling all employment-based visas and green cards for its U.S.-based clients. Steve has represented clients at approximately 50 U.S. embassies and works with franchises and service-oriented businesses in order to create investment opportunities for foreign nationals to obtain investor visas and EB-5 green cards, as well as assisting foreign companies who want to expand their businesses into the U.S. As a former immigrant and naturalized U.S. citizen, Steve understands the legal immigration processes on both a personal and professional level and has the experience and know-how to assist clients both in the U.S. and abroad. Today, Steve will be speaking on U.S. immigration in the time of Corona. And with that introduction, I'll now turn the program over to Steve.
Thank you so much, Jonathan. Appreciate it. I'll share my screen now. So welcome, everyone. Thank you so much for joining us. This has been a crazy year and a half, and it's hard to resume this in 28 minutes, but I'm going to try. Before I get started, I want to give some of you a background as to what are the major players in this U.S. immigration system. I call it the four-headed dragon. And what we've got here, as you can see, is USCIS, which is Immigration Service, Department of State, which controls the embassies and consulates, Customs and Border Protection, which decides if you can come into the US or not. And then the major player now through executive actions is the executive branch. And we're going to talk a little bit about these, and then I'm going to talk about what's happening now. So this most powerful dragon right now in this four-headed dragon is the executive branch. And that's because it wields the power of the pen. And with one signature, can change how the laws are applied. As many of you know, immigration law has not changed. In 35 years now, since 1986, there have not been any comprehensive immigration changes. And so these executive memoranda, proclamations, and orders are all variations on a theme, but they have the same effect of immediately putting changes into effect. And those have really shaped the way that policies are implemented, especially because of the coronavirus. Now, as many of you know, the only way to negate their effect is getting a temporary injunction in federal courts. And that's very difficult to do. So a lot of them are in place, and they continue to be in place. This administration, one way that they can be undone is to sign a new executive order. And so that has happened to some degree. This administration has started to undo some of this, but new similar orders can be issued when those are quashed. And so this is the most sort of extreme abuse of power that we've seen, and it changes the way that our clients can function, what they are or are not able to do overnight. Let's talk about immigration service. This is part of Homeland Security now as of the Patriot Act after 9/11. And this has been the key to maintaining legal status during the pandemic. Because the US embassies and consuls have been shut down completely or partially since March of last year, now they're starting to operate to different degrees. This is really important to utilize USCIS. If your clients or some of you might be foreign nationals are in the United States, you have to make sure that you're maintaining your status by submitting what's called an extension of status or a change of status, or maybe starting a green card process. Under the Trump administration, the denial of cases tripled compared to the Obama administration. We do not have any numbers yet when it comes to the Biden administration, but we're talking about the same personnel that's in place right now that was denying cases under Trump. And so you have to present very strong cases when you're talking about USCIS. Customs and Border Protection is the final gatekeeper. These individuals that work for CBP have almost uncheckable power at these ports of entry. And that means that even with an approved petition from USCIS and a visa approved by the Department of State, you can still be denied entry to the United States if you're found to be inadmissible by Customs and Border Protection. And so it's very important to be ready, to have the arguments ready when you go through every single one of these fronts when you're battling immigration service. A denial at the border, somebody being sent back, means that it's very difficult to appeal those decisions. And you're probably going to have to end up applying for a visa again at the US embassy or consulate. And that's very difficult to do once you've been kicked out of the country. So that's the third. And then the Department of State. This is really an X factor here because each embassy and consulate is its own island. And this has become a huge battleground now because of COVID. The administration has shut down entry to the United States for many people to come directly, and because it's been very difficult for people to get visas, even if they have approved petitions in the United States. There are bottlenecks of 6 months or more on visa processing. And then a lot of these embassies and consulates, because they're so popular, like the one in Paris or London or Amsterdam, there's so many people trying to apply, there is a huge bottleneck, and that's only getting worse. And that includes people that we really need in the United States, of course, like skilled labor, STEM field people. And then in what I focus on primarily in my work is entrepreneurs, business owners, and then investors. And then those are the people that we really need here to create jobs in this time of high unemployment. So what's happening now? Biden has started to undo what the administration did under Trump, and there were over 400 modifications to the application of the laws under the Trump administration, believe it or not. There is a direct entry ban on 36 countries now. They added South Africa, they added India recently. That means if you have clients overseas and they want to come to the United States, they cannot do so directly if they're living in one of these 36 countries unless they apply for what's called a national interest exception. And I'll tell you what that entails and what the criteria is, but this is not used for tourists. This is used for business or investment purposes, which is, of course, Jonathan works with family offices and with people of high net worth. And some of those people are executives or entrepreneurs or people who run companies. And that's where we overlap. There was a bar on the issuance of immigrant visas, L1, H1B, and J1 visas. So these are some of the professional or training visas that you might have heard of. That was undone by the Biden administration, and now they are processing some of these visas. But really the only ones that people can get right now are F1s, which are student visas, and J1s, which are interns or trainee visas. So you have to plan ahead when your clients are applying for visas. The only ones that are readily available now are the student and trainee visas. As I mentioned, USCIS continues to function, so we're going to talk about the importance of maintaining status in a moment. There was something called the public charge rule under Trump, which was a way for any case to be denied if the person hypothetically could one day apply for public benefits. Luckily, that was undone because that would have set a precedent of a huge wave of denials. And then the national interest exception that I mentioned, which is applied for through the US embassies and consulates, that is constantly changing in terms of the standard. Now it's been loosened up again after being restrictive for 3 months. So this is something that's changing all the time. I have heard of cases where people were denied for this because they didn't understand what the standard was at the time that they applied. And that's the only person that's going to know that is an attorney that specializes in consular work, working at the US embassies and consulates. One of the visas that I work on the most is E2. That's an investment-based temporary visa that's available to people from 81 countries that have a treaty with the United States. And each embassy and consulate is different. So in Amsterdam, I got this email for a case I was going to submit saying that they were accepting the petitions, but they were not giving appointments, meaning that they're going to put it in the queue and then it's going to wait to be processed. And that's the case in several of these embassies, but you need to check embassy by embassy what their policies are. There are some like Paris that are not accepting any E2 petitions at all. So what are the different scenarios for your foreign national clients? They're already in the US, they're outside the US, but hold a work visa, so they may be able to come through a national interest exception. They're outside the US, but have active what's called ESTA status. So if they're from one of 39 countries that are part of what's called the visa waiver program, they don't need a visa to come to the United States for up to 90 days as a business or pleasure visitor, but they do need to get the national interest exception. So the base for a national interest exception is you must already have a visa or active ESTA status. The last two scenarios are they're outside the US, with an approved USCIS petition. So you'll see this for people who have L1 managerial or executive visas or O1 for extraordinary ability. They might have an approved petition in the US, but they have to get a visa stamp. And then the last one is outside the US with nothing in process. And that's the longest term scenario here. So for those people in the United States, when in doubt, don't go out. You must maintain your status at all times. So if you have clients that are physically in the US, they need to look at this document called I-94. And what you need to do is simply just Google I-94. There's a Customs and Border Protection page just for looking up your specific status. And what you need to look at is most recent entry. When you pull that up with your passport information, it will show you when your last day of authorized stay is. And this is the controlling date. So you may have, for example, an L1 visa for a multinational manager or executive that is for 5 years, but you might be limited to the end date on the USCIS petition, which might be 2 years. And the I-94 will reflect that. I have a client now who didn't look at their I-94. They realized they're a month overstayed in the United States. So it's very important to make sure that you're looking at your I-94. If any of you have clients who are here that are foreign nationals, tell them, check your I-94 status, because otherwise they may fall out of status. So you have to be ready to apply for an extension of status in the United States. And if you're in the green card process, you also have to maintain your underlying status, meaning if an employer, for example, sponsors you for a green card and you're on an O1 visa, you still have to keep that O1 status in place by extending that status. Do not leave the United States without a valid visa or without an appointment. And here, this is where it gets really complicated, is a lot of these embassies now are canceling or postponing appointments. And so when in doubt, don't go out, because otherwise you will incur what's called unlawful presence. And once you're in unlawful presence, meaning you've passed the date of your I-94, you may not be able to come back to the US once you've left. If you've overstayed more than 180 days, there's a 3-year bar. And if you've overstayed more than 1 year, then there's a 10-year bar. And do not rely on COVID as an excuse for overstaying. Don't think that one day you'll apply and you'll say, I couldn't leave because of COVID, because if you really want to leave the US, you can. For those of you who have employees who are foreign nationals who you're sponsoring, the most important take-home lesson is here: no job, no status, meaning if they are no longer on payroll or you've terminated them, they are now accruing unlawful status. And so if you are thinking about letting someone go, or you want to downsize in terms of hours, you want to keep them on payroll, because once you've lost them, then they're out of status and they have to leave, unless they're on an H-1B visa, which gives them 60 days to find a new sponsor and submit a new petition. But in most cases, you're not going to be able to bring them back on payroll and continue to sponsor them, because technically they will have fallen out of status. So when in doubt, keep them on payroll, even if you're minimizing their salary. A lot of people complain that, or they make a facetious joke that it's easier to get into the US illegally than it is legally. And there is some truth to that. That's why I have this comic here about the wall, which says immigration laws. it has become very difficult to get into the United States, but that's my job, is to get people here legally. So let's talk about something that has stayed the same throughout this, since March of last year. Who can still come in without any problems? That is US nationals, permanent residents, spouses of US nationals and residents, and then parents of unmarried or younger than 21-year-old US citizens or permanent residents. And then we've lastly got crew members and diplomats. That's stayed the same. So if you know someone who's a crew member or diplomat, they can come to the US. There's no restrictions for them to come even directly from one of those restricted countries if they have one of these visas or they have this immigration status of being a national or a resident. So how can foreign nationals enter the US now? So it's important to note that if you live in a country or your clients live in a country that is not one of the 36 countries that's restricted, then you can fly directly to the United States. So that's essentially all of South America except for Brazil, all of Asia, the majority of the Middle East, Australia, for example. So where you are is what dictates whether you can come directly to the US or not what nationality you have. In many cases, the triangulation option is better or faster than applying for what I call the national interest exception. And I'll talk about that, because the national interest exception, either you don't qualify under the requirements or it just takes too long to get it approved. I have cases where we've been waiting 5 or 6 weeks. So your option would then be, let's say you have a client in France, they fly to Dubai or they fly to Istanbul or Mexico City and they stay there for 2 weeks before they enter the United States, and then they won't have any problem and they won't need the exception. What if that is not an option? Well, let's talk about the basics of the national interest exception. You must already have ESTA status or a visa, like I mentioned. There's no penalty for applying and being denied. You won't have your visa revoked. Applications are filed by emailing the corresponding embassy or consulate that you are living in. In other words, if you're living in Holland, then you're applying through the consulate in Amsterdam. The rule of thumb is if you are in a rush to get to the US, you may be out of luck. And so you have to make sure, number one, that you qualify. So you need to pre-qualify and look at the standard and see if you might qualify before you apply. And you have to be in that country physically. So you can't be in the United States, apply for an NIE, and then go to Holland or whatever country you were residing in and come back into the US with the exception. You have to take the chance of being in that country. And so it's important to pre-qualify yourself by talking to an individual who understands what the standards are, because attorneys can represent their clients in these petitions through the embassies. Let's talk about the qualifying criteria for NIE. This is called business and significant economic investment. So this was the standard, it was replaced, now it's accepted again, thank goodness. That's because this is great for anyone who's doing development of a US business or doing a project in the United States that helps move the economy forward in conjunction with US companies. So you need to explain in your presentation what the activities will be, what the significant economic investment is, and what the benefit will be. And then the most important thing is, why do these activities require your physical presence, and why can alternatives like video conferencing or teleworking not be sufficient? Why do you have to be physically in the US? So this standard is now being used again. The one that it was replaced by and now is open and they're working in conjunction is critical infrastructure. So if you're coming to the US to work on any project that is within this list, and you can see the link down at the bottom to make sure that you qualify. If you are working, for example, a lot of my clients do food and agricultural services. They help build out things like greenhouses in the US, for example. So that qualifies. And when you have a project and you're coming to the US for this specific purpose, you should qualify for the national interest exception. There's some good news. As of June 29th, the NIEs are now 1 year long, and that's retroactively applied, which means that if you were granted a national interest exception in the past 12 months, you can use it again to re-enter as many times as you want directly from one of these restricted countries, right? So that's the important thing to keep in mind. And this is only for restricted countries. So if you were approved on October 2nd of last year, you can use that NIE until October 1st of this year. I just had clients that were approved this morning. They're traveling in a few days. They will have it for 1 year. We don't know how long this is going to exist before they lift the restrictions. But the important thing to keep in mind is that if your approval is now more than 1 year old, because it started about a year ago, then you will have to reapply or triangulate. So this is a great tool to help get entrepreneurs and people working on important projects and investors to the US, especially when they've set up US operations in order to move those projects forward. What if you don't have a visa? Well, there's something called forum shopping. And this is something that I've always discouraged because the waits are so long that it might be in your client's best interest or yours if you're outside the US and you have an approved petition and you need to get a visa to come into the US to work, to also look at potentially other consulates and embassies. So I'm going to give you an example. I got an O1 visa, extraordinary ability visa approved for, the petition was approved for a Dutch singer. She got an appointment for June, it was canceled. She got an appointment for September, it was canceled. Then it looked like it was going to be in December that she would have it. So that means that she would have lost already 9 months on her O1 time, which is 3 years minus 9 months. And she looked around and found that in Bern, Switzerland, the embassy had waived the residence requirement. And she got an interview very quickly and was approved. Now she's in the United States. Then we applied for the national interest exception, and she got it because she's going to be working on musical productions and recordings that will help create work for sound engineers and other people in music production. So it's important to let your clients know this. They can have pending appointments in several consular posts. You have to pay that $250 fee to get an appointment, but at least they have the option of potentially looking at other embassies and consulates if there's a huge backlog on their cases. Last take-home lessons and the conclusion. There's still no end in sight for the lift on this direct entry bar, and the clearing of backlogs could be into next year, but the 1-year national interest exception extensions are helpful. USCIS is still accepting and processing petitions, so utilize it by changing status, extending, continuing your green card process. And as I said, do not leave the US without a plan because you might be stuck for a very long time without being able to get a visa. So if you're in the US, try to stay here. COVID-19 continues to be this X factor which justifies policies and creates these delays on issuances of visas. And the functioning of consulates is still not even close to 100%. And it really depends on which consulate or embassy, US consulate or embassy you're dealing with. So you have to be able to know the state of affairs in all these different, what we call consular posts. You need to expect backlogs on visa processing and plan accordingly. So that might lead you to get appointments now or to forum shop, as I mentioned. Use the national interest exception as a tool and stay on top of changes, of course. There's another thing that I suggest too. If you're going to submit a case for someone to sponsor them for work visa, push back the start date for 4 to 6 months, not now, because let's say you sponsor someone for an L1 visa to transfer them to the US. You can get 1 year if it's a new office in the US or 3 years if you're an existing business with generating revenue. But if you submit the case now with the start date of August, let's say, and it's not approved until February or March because that's when they get their appointment, they will lose on the back end because the end date is the same. They will lose those 6-7 months upfront on their actual visa time. So if you want to maximize the amount of time that your employees can work in the US, then you need to push back the start dates on your petition. And I guess the last thing is always watch out for the four-headed dragon, meaning keep in mind that there are 4 different phases here of immigration process, and you need to be on top of each one of those or work with somebody that knows how all these work together in order for you to protect yourself and your employees and your clients as well. That's it for today.
Great. Thank you so much, Steve. I know we were worried about time, but you finished that very succinctly and in record time. So we had nothing to worry about. If anyone has any specific questions or new business opportunities, I'll be sure to leave Steve's email in the follow-up to this program, and you feel free to reach out to him or myself where appropriate. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management related topics and to collaborate where appropriate. And I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. Two more quick items before I let you go. First, my next program will be on Thursday, July 22nd, and is entitled 2021 Wealth Management Hot Topics, Actionable Insights on the Top Investment Themes of the Year, featuring yours truly, Jonathan Shenkman. Given the action-packed year we've experienced with no shortage of tax, investment, and political news stories, I anticipate that this webinar will be informative to both investors and practitioners. I'll be sure to include actionable ideas, so it should be helpful to everybody. And this is my last program until the fall, so don't miss it. You'll receive an invitation to this webinar and all of my upcoming sessions in the coming days, and I hope you can attend. Second, please be sure to take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees, and I thank you in advance for that. And with that, this concludes today's session. Please stay safe and healthy. Have a wonderful day, everybody.
Thank you.